Before we even get into the meat of this hearing, you need to know, this is no ordinary custody dispute. We've got two parents who have been running their own 50-50 schedule for years without a court order. Until now. The judge, he's skeptical of 50-50 arrangements unless both parents live close enough for it to actually work. And today, both sides are being put to the test. We'll hear about everything, from school zoning restrictions to extracurricular commitments, and even a ticking 72-hour clock for one dad to hand over insurance documents. But pay attention closely, because while both parents appear cooperative, the cracks in communication start to show, and the judge's patience will be tested. Will this end in harmony or hidden conflict? Let's dive in.
Because I'm not a big fan of 50-50.
Yes.
All right, then, sir, are you there?
I'm here, yes, sir.
All right, but I ask you both to raise your right hands. Do you both solemnly swear or affirm me testimony going to give here today the truth, the whole truth, and nothing but the truth so help you?
Yes, sir.
All right,
Yes, sir.
okay, you're both officially under oath. Mr. Diamond, who do you want to approve this or not?
I would I would defer to the other attorneys, Your Honor, if it pleases the court.
Okay, then. I'll tell you what, let's go with the Ms. Obede, and then we'll, of course, you and Ms. Huzak will have the opportunity to cross-examine and confirm also.
Okay.
So at this time, Mr. Obede, I'll let you go ahead and call your first witness and prove this matter up. Thank you, sir.
Okay.
Notice how the judge is already setting a tone here, polite but firm. He's making sure both parties are visible and unmuted, because in family court, even small details like eye contact and responsiveness count toward how cooperative you appear. Viewers, ask yourself, if you were in this position, would you already be on edge? Because the subtext here is simple. The judge is watching everything.
All right. Mr. Felton, you are muted. Can you unmute yourself? And also, Ms. Lloyd, if you don't mind, can you show your video, if you don't mind?
Ma'am, turn your video on and unmute yourself, please.
Yes, sir.
You're good,
Okay,
sir.
I'm here.
Ms. Lloyd.
Okay.
All right, thank you.
Thank you. May I
right.
proceed on?
Yes, you may.
All right, Mr. Felton, can you just state your full name for the record one more time?
Blanchard Rayvon Felton.
Okay. And you are the father of the two children involved in this case. Is that correct?
Yes, sir.
Can you state their names and ages, please?
Okay, my first son is Blanchard Rayvon Felton Jr. He's 8. Then I also have Denham Raylon Jerome Felton, and he's 5.
All right. We understand that you signed an acknowledgement of paternity when the children were born. Is that correct?
Yes, sir.
And are you asking this court to confirm today that you are in fact the father of these children?
Yes, sir.
And you want the court to adjudicate you as the parent, as a father for all intent and purposes?
Yes, sir.
All right. So prior to today, you and Ms. Lloyd, you worked out your own visitation. Is that correct?
Been doing the same thing. Yes, sir.
All right. How long have you been doing this visitation? How long has it been in place?
Since we've been split about 3 years. Yes, sir.
3 years of an informal 50-50 arrangement. That's no small feat. Many co-parents can't go 3 months without a dispute. The fact that they've managed to stick to Tuesdays without major issues, that's impressive. But it also means the judge is thinking, if it's not broken, why fix it? Still, the law likes certainty, and that's why a formal order is coming.
Okay, for the past 3 years. And
Yes, sir.
has it always been from Tuesday to Tuesday?
Yes, sir.
Okay. And so far, how is that working out for the children?
I think it works great. Anything that needs to be done, if it's anything that needs to be done, we can speak upon it. But as far as for the kids, I think they are comfortable with it. I think they enjoy it because they get both parts of the side. It's both parents. But as far as Tuesday to Tuesday, I think they're comfortable, and I'm comfortable with it too.
Okay. And then when you guys started this 3 years ago, you both also agreed to pay half the expenses for them, right? Including daycare at that time?
Everything that's towards them, we're going to go half on each thing.
Okay.
That's daycare, whatever it is.
Okay. And if the court were to change it, how do you think, do you think it would be in the best interest of the children, or do you think it's in the best interest of the children to keep it the way they are?
I think it's for the best of interest for us just to keep it the same way. They're used to that, and I'm accustomed to that. I know mom is accustomed to that. That's what we've been doing for the past 3 years. So I don't feel like it's anything that needs to really be changed.
This is a huge moment. Dad is effectively saying, if it works for us and the kids are happy, don't change it. In family law, best interest of the child is the gold standard. The court isn't swayed by what's most convenient for mom or dad. It's about stability, routine, and minimizing disruption. Right now, Dad's testimony is ticking all the right boxes.
Okay. Which school districts are they zoned to right now?
They're in the KISD
Okay.
school district.
Okay. So are you okay if the judge restricts both you and mom to continue to reside in that school district so that this 50-50 will work?
Yes, sir.
Okay. And you believe that restriction to KISD will be in the best interest of the children?
Yes, sir.
Okay. And also you told me, I want you to state it for the record, that you currently have medical insurance for your children.
Yes, sir.
Is that through your employer?
Through my employer. And no, I have Blue Cross Blue Shield. So that's currently not on my through my job. It's my own.
Okay, but whatever insurance you have, they cover the
They're
children.
on it. Yes,
All
sir.
right.
Both of them on it.
All right. Does mom have a copy of that insurance?
She doesn't have a copy of it.
Okay. Well, since we are reaching an agreement now, and she's gonna have the time, will you commit to deliver a copy to her within the next 24 hours?
Try my best. Yes, I can. Try my best.
Okay,
Anyway,
please make sure.
let's make it 72 hours, Mr. Obey.
72 hours. Okay. Okay.
Yeah, that way, because he might have to get some extra cards, okay?
Okay.
This might sound like a minor administrative detail, but in reality, health insurance is one of the most heavily enforced aspects of a custody order. The judge isn't just asking nicely. He's putting Dad on notice that failure to comply could bring him right back into court. For you at home, never underestimate how quickly a small task can become a legal problem.
Right.
But if it's Blue Cross Blue Shield, you can print those out online, sir, and give her a copy, okay? Because that's what I do. All right.
Okay.
Thank you.
You understand the judge, Mr. Felton?
What was that? I was trying to see the timing that you said.
Yeah, for 72 hours, which is 3 days from today.
Yes, sir. Yes, sir.
All
Understand.
right. Make sure you send me proof. Like, send out an email, copy me on it. I need to know, okay?
Got you.
All right. So this judge is going to order you to continue to maintain that insurance, okay?
Good business.
If for whatever the reason is, you have to change it, you have to notify me so I can do what I need to do legally on your behalf.
Will do.
Okay. And visitation right now, where do you guys do the exchanges for your children? Is it at your house or at school?
As far as visitation,
Yeah, where does Miss Lloyd, where does she pick up the children from?
well, when they go back with mom, when they was in school, they rode the bus. When they were with me, I picked them up. So as far as when they on that Tuesday, when I take them to school or whatever, when they take them to school, then later on that day, I don't know as far as unless they had any practices or anything like that. But other than that, they go back to mom. If I don't know anything as far as practice or anything like that, I don't pick them up or do anything unless I got, if she let me know something, you can pick them up or something. Other than that Tuesday, my time is, basically done for that week.
Pay attention to how Dad explains the exchange process. Smooth handoffs are the grease that keeps the co-parenting machine running. But notice, he slips in a detail about sometimes picking the kids up from a gas station. To the court, that might raise eyebrows. Why not a consistent, safe location every time? It's not a red flag yet, but the judge will store that away.
Okay, so let me restate what I think you said, okay? Pick up, whenever there is school and there is exchanges, both of you will pick up the children from school. Is that correct? Right? And
If
then
it's any changes, we'll talk to each other, pick up or however it is. But the schedule is that, Tuesday when I pick them up, my week, I go to the school and pick them up. When they go back with mom, they rode the bus to mom's house.
Okay. And also when there is no school, right? Let's just say during the summer, the pickup will be, the exchange will take place at your, parents' house. Is that what you are doing right now?
Well, yeah, basically, when it's the change shift, she will come get them, or she'll notify me and tell me a time that she will come get them. But it's like when I will ask her or something, I don't get the same, answers or something. But yeah, it will. If I have to meet up with her, and last time I just picked them up from the gas station and stuff
Okay.
before we went to the church. But other than that, we drop to the house.
Okay, okay. But it's okay if right, remember you don't have a court order, but the order is going to stay when there is no school. You guys are going to exchange at your parents' house. Is that okay?
It's okay.
Okay.
If there's any changes, yeah, just let you know.
Okay,
Okay.
okay, you now understand it.
Keep
I'm
it-
just going to say something specifically. Obviously, y'all can change things around, but right now, if there's not an agreement, the exchange is going to take place at your parents' house. Understood?
Here we see the judge locking in a default exchange location when school isn't in session. This is a safety net. If communication fails, there's no confusion. Experienced family lawyers know vague agreements are breeding grounds for conflict. This clause protects both sides from "I didn't know" arguments later.
Sure.
All right.
That's what I understand, and that's what that's what I'm going to allow in the court order. But yeah, again, y'all can do something different, but you got to be on the same page of that. Otherwise, the exchange is automatically at your parents' house. All right, thank you.
Just two more
Yes, sir.
two more questions for you. In terms of child support right now, you guys are not, I mean, basically each of you is taking care of your children during your time.
Yes, sir.
And you're asking the judge to continue that, but not to order any parent to pay child support to the other one.
Yeah, not have to pay anything, but yeah, keep doing what we've been doing.
No child support being requested here, unusual in many cases, but not unheard of in true 50-50 custody arrangements. The key takeaway? Both parents are financially self-sufficient enough to handle expenses during their own parenting time, but this also means the court will expect strict adherence to that split. No one can suddenly shift financial responsibility onto the other without reopening the case.
Okay, and then lastly, in terms of conservatorship, are you asking this judge to name you both as the joint managing conservator of the children, and then for you guys to share decision making?
Yes, sir.
And you believe all these things you are telling this judge to do for you today, they are in the best interest of your children?
Yes, sir.
And you want this judge to approve this agreement if Ms. Lloyd confirms it?
Yes, sir.
Thank you, Your Honor. That's all the question I have for Mr. Fertin.
All right, Ms. Kuzak, you're a witness. You muted, ma'am. Yeah, they did it again.
When it comes to that, that's the one thing I just don't catch on quick for that. I just assume I'm out in the real world out here. But okay, so I don't have a whole lot of questions. I'll just ask you, Mr. Felton. The kids are doing good in school, right?
Yes, ma'am.
Are they both on honor roll?
DJ was on honor roll, and Denham, he's a pre-K, but his grades was up to par.
Okay. So both kids are doing well in school. Are they both also involved in extracurricular activities?
Yes, ma'am.
Okay. And so is it important that these kids make it to these extracurricular activities?
Yes, ma'am.
So they're in soccer and baseball and all the different, youth sports, right?
Yes, ma'am.
Okay. Do they also volunteer?
Yes, ma'am. They also volunteer.
Okay. So we don't have kids who are just sitting and like gaming or something. These kids are responding well to each household, right?
Yes, ma'am.
And they're not just doing an average job at being kids. They're kind of thriving, right?
Yes, ma'am.
Do you feel that also shows why this schedule has been working for these two boys?
Yes, ma'am.
The attorney is highlighting something powerful here. These kids aren't just doing fine, they're thriving. Honor rolls, sports, volunteering, all of it paints a picture that the current arrangement is fostering success. Judges love evidence that stability equals good results. If you're ever in court, this is the type of narrative you want on your side.
Okay. I pass the witness, Judge.
All right, thank you. Mr. Diamond.
No questions, Your Honor.
All right, Mr. Obede, you can call your next witness, please. Thank you.
Yes, Your Honor, I'll call Ms. Lloyd.
All right, Ms. Lloyd, you there, ma'am? You need to unmute yourself and state your full name for the record, ma'am.
I'm here, Janelle Lloyd.
All right, thank you. You may proceed.
Miss Lloyd, how are you today?
I'm doing good. Thank you for asking. How about yourself?
I'm doing well. Thank you for your patience. I will be dealing with it for 2 years, but just going to ask you a few questions just so we can wrap it up, okay?
Of course, yes, sir.
All right. So you heard all the questions that I asked Mr. Felton. Did you hear them?
Correct. Yes, sir.
And did you understand them?
Yes, sir.
Okay. Are you asking the court based on what he said he wanted, or I'm sorry, based on what he said the agreement was, are you asking the court to approve this agreement?
Yes, as long as we keep everything 50-50 drawn down the middle between the two. Yes.
All right. So is there anything regarding the question that I asked him that you need clarification on?
No, sir.
Okay. So do you believe that this agreement, if approved by the court, will be in the best interest of your children?
Yes, sir. Actually, I'm sorry. I do have a
Here's a subtle but important moment. Mom admits she doesn't fully understand the geographic restriction. Some viewers might think, so what? But misunderstandings about legal orders are one of the top causes of post-judgment disputes. The attorney and judge jump in to clarify immediately because confusion now could mean contempt motions later.
question. I'm so
Yes.
sorry.
Okay.
Going back to the KISD, I didn't quite understand. So there will be
I can
zoned for KSD, correct?
Yes, I can quickly clarify. Since if you guys are
Okay.
doing 50-50, remember what the judge hinted that it is not a big fan of 50-50 because you cannot really move to Dallas, right? You can't move too far. So in order for this 50-50 to work, we have to keep you guys around the same place. And that school district is the best way to gauge, you know where your children are going to be going to school. So if you choose to move too far, then that's kind of on you. So the judge is basically going to say, for the purpose of designating the residence of the child, it's going to be that the children have to live within that school zone.
Okay, got it.
That's what that is. But if you want to move to Dallas tomorrow, then you may need a modification so that, that will be workable. Okay, but 50-50 requires a geographic restriction for it to work.
Okay.
Okay, are you committed to making this work?
Yes, sir. It's been working since 2021. So
So are you asking this judge to approve it and also included that geographic restriction of KISD that I just explained to you?
yes.
All right, and you believe this will be in the best interest of your children?
Yes, sir.
All right, that's all the question I have, Ms. Your Honor.
All right. Thank you. Ms. Cusack.
Thank you, Judge. I'm not on mute. So, Ms. Lloyd, I'll ask you the same question about school and everything. So,
Okay.
could have been some like where you guys have had to work on communication for getting things turned in and that kind of stuff. But generally speaking, these kids are doing well, right?
Yes, ma'am.
Okay. We heard the reference to the bus, that the kids take the bus to your house. So have you traditionally all this time been the house that designates where the kids go to school?
No, ma'am.
Okay. Well, how have the kids been coming home to you on the bus? What I'm getting at is where are the kids going to go to school?
Oh, the kids. So I rezoned. So they'll actually be going to Fowler Elementary. So for me, I mean, I know Dad didn't take the option, but they will be bused here as well. So it'll be kind of the same thing that was going on last year. When I get them, they'll be put on the bus or dropped off at school or picked up at the bus, and then Dad's week he'll go get them from school.
Okay, and he's always traditionally picked them up, either him or through his family, because his family
Correct.
lives, right? Okay. Do you feel that these orders, given all of the where you guys started as a separated couple, do you feel that you kind of grown into something that could be healthy going forward?
Of course, yes, ma'am.
And are you asking the court to lock this in?
At this point, both parents are essentially asking the court to make their handshake agreement legally binding. But once the judge signs, it's no longer just our arrangement. It's a court order. That means enforcement power, consequences for violations, and a whole new level of accountability. For cooperative parents, that's fine. For those who slip into conflict, it can get messy fast.
Yes, please.
Okay. I pass the witness, Judge.
All right, thank you. Mr. Diamond.
Yeah, it's just one question, Your Honor. Miss Lloyd, I'm sorry I missed it. The Fowler Elementary, is that still in KISD?
Oh, yeah,
Yes,
that's
sir.
KISD.
It is.
Oh yeah, you know, I'm sorry. The judge went to Killeen for 7 years and Belton to 5. I'll approve VISD, man, if you ever want to move over to Belton too. But yeah, and my mom was a Killeen Teacher of the Year 1 year, so yeah. Well, I know where those elementary schools are. At least the old, the new ones, yeah, I'm a little bit off on. So yeah.
Yeah, Fowler moved because it's not at the same, it's a new building now.
Oh, okay. See, I didn't know that. Thank you. But I know that sometimes they keep the same names, but they're moving around. I saw that East Ward is no longer East Ward now. It's Killeen Elementary, and that kind of shocked me the other day. But yeah, I got it. Thank you.
Yes.
Yeah. So yeah. Anything else? Any other questions, Mr. Diamond?
No, Your Honor.
All right, folks. Sounds like a deal to me. And again, like I say, ma'am, if you ever want to come back and go to BISD, let me know. Okay, because Belton and Killeen, those are my schools. So all right. But anyway, I'm going to go ahead and grant the agreement. I'm going to name you both joint managing conservators. I'm keeping the right to decide, ma'am, you get to decide the domicile so long as it remains in the KISD. And yeah, if you come to Belton, yeah, that's not that big of a difference. But yeah, it's close. And, they barter each other, and sometimes that comes into effect. But yeah, right now it's going to be KISD going forward. Obviously the exchange is still going to take place on Tuesdays. Y'all do your own transportation. You folks are working together now, so you can use your phone and the text and call each other. I'm not gonna mandate that y'all remain on the app close. When I got parties that are not getting along together, I prefer app close because the app close gives you printouts of everything precisely. Whereas if you ever tried to get somebody's 80 pages of text message in evidence, it's an absolute mess. But y'all are doing well, so I don't think I have to worry about that. So yeah, let's go ahead.
And there it is. The judge approves the agreement, names both as joint managing conservators, locks in the school district restriction, sets the Tuesday exchanges, and confirms 0 child support. This is about as clean an outcome as you'll see in a custody case. Both parents walked in aligned, and they walked out with a legally enforceable plan that mirrors what they've already been doing. But remember, today's cooperation doesn't guarantee tomorrow's peace. The real test begins now, and time will tell if this arrangement can survive life's inevitable curveballs. If you found this case as fascinating as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.